nonprofit operating agreement. Like I said, it take me 5 minutes because I just use the same one that I generally use for everybody because you're in charge. Just does what it should do. But if there's more than one member and, you're figuring out, okay, who's going to do what, who's going to contribute what, are we all going to be even? I've had LLCs where people do different roles, right? I've done them where I've put in some cash and I've acted as the lawyer. Somebody else is responsible for running the construction. Somebody else is responsible for picking designs and things like that. So I've done fairly complicated agreements depending on a particular real estate investment deal. So it can be done. And you can do it ahead of time. So, you can actually, if you say, I have a couple people who I want to partner with, and we've decided we're going to look at some real estate investments. We're looking for deals. We haven't found one yet. You can actually figure out the structure in advance. And then when you form the LLC, that's your operating agreement. So that's what it says. It's called a pre-formation agreement. And then it becomes the operating agreement as soon as you activate the LLC. So again, it's smart if you have your members together and say, we're going to be looking for deals. Let's invest some time. Let's figure out exactly how we're going to deal with each other, whose role is going to be what. And then we go out and get the property. Because if you try to bite all that at one time, right, it's a lot to chew. It's a mouthful. So maybe you start ahead of time. And like I said, I've had clients who've used this to great success. And the other thing is, like most things, unfortunately, there is an operating cost in the beginning, right? You've got to spend some money. Just like when you do a deal, you've got to do your due diligence. You got to get, if you're buying a sheriff's sale, man, you got to get a title report. I don't care if you don't win. I don't care if the deal dies. You need to get title insurance to know what you're buying. In a regular deal, sure, you can wait until the end and see what happens. But ultimately, you're going to have to do that. You're going to have contractors or somebody, a home inspector or something, go out and take a look at the property. You've got to do a level of due diligence. Same thing. You've got to structure your business, have a good lawyer and a good accountant help you get these things set up. There are upfront costs. And as the deals, if you don't get a deal, you're going to be spending money. Tank sweep, all these things that you have to do for each individual deal that you look at, the farther along you get, but you have to do it. Because if you don't, the downside is a lot worse than the upside, right? So again, it's all this goes under the label of do your due diligence, do your homework, protect yourself, sleep at night, it's worth it. Don't scrimp and save and cut corners in the beginning because that's when you really want to make sure that you've got your structure set up. Then you can go and start rocking and rolling with properties. It's just, to me, there's really no other way to operate. It's doing it in a controlled, organized, thought out manner versus, oh, geez, what am I going to do now when you're trying to deal with 6 other things? So anyway, all right, next slide.
Sure. Just to add in a little bit, I always tell people if you're planning on being in real estate long enough, there will be a day that a hiccup or a problem will come about, and it's better to be protected. And everyone usually comes in with long-term goals, so let's keep those in mind. Exactly,
and you have to think about what your exit strategy is really on the way in, right? I mean, it can always change, but with your LLCs, you definitely want to do that because, hey, if everybody's making money and getting along, and things seem to be working out and everybody agrees, of course there's no problems. I always say, right, we wouldn't need contracts if, people didn't breach it, right? If people didn't somehow default, we wouldn't need loan agreements. We just operate on a handshake and everybody would pay. And frankly, there's plenty of borrowers out there who will honor their commitments. Doesn't matter what the document says or doesn't say. If you're an honorable person, and that's, the lenders appreciate that. I mean, I've been either a lender or a borrower's lawyer my whole career, and I'm a bankruptcy lawyer. I take deals, when times are good, I'm putting them together. When times are bad, I'm taking them apart. We're going to bankruptcy and, picking over the bones, trying to make the best that we can in a restructuring. But, it's if somebody is going to be a person of their word, that's the kind of person you want to do business with, whatever side of the table you're on, even if it's round, whether you're over it or under it or whatever, right? All right. So like I said, there are default provisions. So if you don't, you can go to the next slide. That's more for like I already said. So we're rolling through this. Yeah, some key provisions under the, like I said, if under the prior act, capital contribution is determined. Now it's per capita, meaning however members there are. So listen, but many times, by the way, you can be a member and there's no set rules. You don't have to have equal capital allocations. Sure, a lot of times we do, but a lot of times we don't. And guess what? You don't even have to have a percentage interest to be a member. You can be a member and say, it's just like a lender, but you're really an equity holder. You're not debt like Max would be. So in the waterfall, you get paid last because you're equity, more risk, but you can absolutely say, I'm going to contribute $50,000 to this LLC because it's purchasing this particular property and I believe in the deal, but, we're going to use my money as equity and I'm going to get, a 15% return on my money, basically. And I'm guaranteed at least 6 months, worth of that. And I've done that many times. And the other members can buy out that member usually because they just want their money back with interest. So you give them a certain small percentage of interest, so they have some stake in the organization, but really their role is a capital partner, where they're just putting money in as an equity contribution. They don't have a voice really in running the company. They're just getting a return at the end of the day or whatever it is that you guys agree to. Again, that's the hallmark of an LLC, flexibility. So, you don't have to be in for the same percentages. People can put in different percentages of capital, and depending on what they're doing, can get more or less. Somebody that's running the LLC, managing the construction of a property and all the renovation, may get a bigger chunk for less money because sweat equity, so to speak, right? They're actually contributing expertise and time. And somebody else is maybe contributing more money and less of a role in the hands-on. So it's all up for negotiation, depending on, what you want to do. And all of this goes in the operating agreement. Like I said, if you don't say, the New Jersey rule is if there's 3 members, everybody gets a third. If there's 4 members, everybody gets 25%, so on and so on. Okay, next slide. So I hope everybody's excited about this because it's so flexible. That's why I love LLCs, because you get to decide how you want to run it. These are very flexible. Like I said, I have a template that I start with, but man, you can really riff off of that depending on what it is that you're trying to do. And, like I said, who's doing what, who's contributing what, and, what the goals are at the end of the day. All right.
There's a lot of questions, so they're definitely enjoying it.
Oh, good. Yeah, I should take some time for that.
We'll spend some time at the end.
Set up a board of directors. You also, fiduciary duties are important. The only thing you can't do is you can't say that, even if you defraud other people by using the LLC is going to indemnify you. You can't do that. You can't completely get rid of fiduciary duties, meaning, you can't just go out and shoot somebody and say, oh, I'm not responsible. The LLC did it. I was acting as an LLC, rip people off. The law doesn't let you get away with that. Go on to the next, but you can do exculpations like the LLC will defend. You can buy insurance, like I said, for the LLC, and that way the insurance will take over the defense if there's a lawsuit or something like that. But you can go to the next slide.
The next one again?
Yeah, next slide. Yeah, you can have a statement of authority, which could be useful because, like I said, if you're doing sort of a bare bones certificate of formation, like I say, where you're just listing a registered agent, doesn't say who's authorized to act for the LLC. So you could actually record something saying, I'm the managing member, I'm authorized to act for the LLC, or it's 50-50, to whatever, person A and person B, both of them have to sign off on anything in order to act for the LLC. And I told you it's perpetual duration. Also, if you're going to buy a New Jersey property and you have a foreign LLC, that's what it's called. I'm not using that pejoratively. That's what it's called, is you domesticate a foreign LLC. If you're a Nevada LLC or anywhere else, you want to own property in New Jersey, you have to register to do business in New Jersey. And it's New Jersey's LLC statute in 13 made that easy. It's all in line now. Go to the next slide. There's just a few things that you can't do. It's fine. Like, you can't say that New Jersey law doesn't apply. You can't tell the court they have no power to tell you what to do. Things like that. You can't eliminate the duty of loyalty. You can go out and, if you're a 2-member LLC, you can call somebody else and say, you know what, we have this deal, but I want you to get it. I want to screw my other partner, my other member of the LLC. You can't just eliminate that. But that's called the duty of loyalty. But it also, you can circumscribe it. Like, just because there's 2 people that are in an LLC or more doesn't mean that you're not allowed to go get other deals through other LLCs with other people or by yourself. So that's not competition. You clearly say, that's something that you can say. Hey, just because you're a member of this LLC doesn't prohibit you from doing other deals. Just means you have to act fairly and reasonably with respect to this deal and your members of the LLC in whatever it is that you guys do decide to undertake. Okay? All right. Next. That's more like lawyer stuff. Next slide. Okay. And just some other things, it's fine. Yeah, you can't say that I won't wind up the business, where I'm not going to pay my debts in the order that the state of New Jersey requires them to be paid. So just kind of basic things. Okay, and you can't unreasonably restrict the right of a member to try to get documents. Like, even if you're a minority member of an LLC, you can't say, you have no right to see anything, the hell with you. We'll pay you if and when, your 20% interest makes any money. You have no right to see anything, go away. We're 80%, you're 20%. Sorry, you're all voted permanently. You can't do that. You still maintain your rights. You could maintain an action and say, look, they won't even tell me what's going on. So there's things to do. There's ways to get relief if you don't already have it in your LLC operating. All right, I think the next one's the last page. Next slide. Yeah. Like I already talked about, there's different IRS treatments, and the thing I already told it to you, but that's essentially that last snippet there, that last bullet point. The whole purpose of an LLC, it's right in the statute, so it's there for everybody to see, including judges. The purpose of of creating and using an LLC is that what you say, as far as your LLC and how it's organized and governed, it's to be liberally construed to give the maximum effect to the principle of freedom of contract and the enforceability of operating agreements. So you have an operating agreement. The court's supposed to say, I'm looking to that agreement. That says how you're going to operate. If that's what you agreed to, that's what you're going to get. There's a legal principle that says, I'm not going to make a better contract for you. I'm not going to say, geez, you should have done this or you should have thought about that. Just going to say, you know what, this is what you said, so that's what the agreement is, and that's what's going to get enforced, if it comes to that. But, by saying that, it's at least right there that that's what you're supposed to do with your LLC, is figure it out among the members. Figure out how you want to run it. No court's going to tell you, oh, you have to do X, Y, and Z, with those exceptions that are in the statute, and that's what. All right. So let me look at some of these questions.
Yeah, we got a lot.
Yeah.
So maybe we should start through first with the ones that came into the Q&A. So Kieran is asking,
yes,
is it important to have the LLC for each investment in the state the property is located?
Like I said, you have to, if you're going to buy property in a state, if you're using a foreign, meaning an LLC that is formed in a different state, you have to register in that state anyway. Okay?
Right.
So really it doesn't matter what state you form it in, but the real estate purchase, the state in which you're going to buy real estate, you're going to have to pay to register it. So the answer is maybe, right. I could see, if you're going to buy a property in Philadelphia, then you might want to do a Pennsylvania LLC. Because if you use your New Jersey LLC to do it, even though it's right across the river, you're going to have to domesticate it and pay another filing fee. So, it's up to you. New York has that funny requirement still where you've got to publish in a newspaper before the LLC.
Yeah,
you have to advertise. And it still exists.
I think that's why a couple of my clients actually were telling me, like, yeah, I'm using my New Jersey when I registered it. And I was like, why? They go, because I'm not down to do this publication.
Oh my God, yeah, it's crazy. And I just know I've done the same exact thing. I have clients in New York and they're buying New Jersey property and they say, oh, I want to use my LLC. I'm like, yeah, who formed it? Oh, my some accountant or something. I'm like, yeah, did you publish? Publish? Forget about it. Don't. Right. I'm not asking any more questions. Use a New Jersey LLC. Right. Exactly right.
So Kieran has another question. He says, how easy is it to transfer the deed of your property you purchased with a conventional loan to your LLC?
Well, those are two kind of different questions. If you have a deed to a property, oh, you're meaning if you buy something, I see. I think what he means is you buy it individually and then you want to transfer it into your LLC. I think that's what he said. Yeah.
He said yes.
Right. In New Jersey, what I'm familiar with, it's extremely easy. But there's a couple considerations. If there's a mortgage, and like you said, it has a conventional loan, that you have a conventional loan, couple considerations. Number one, you have to be careful because most loans have a due on sale clause, like Max's. And say if you sell the property, but Max, you're not lending to individuals, are you?
We don't lend to individuals, and then the only time we have a sale on due clause is on our short terms.
Right. So like some lenders will lend to individuals to buy investment property as long as they certify that they're not going to use it for household purposes, they're not going to occupy it. It's much safer to do what you do, Max, and just say, no, it's got to be in an LLC because an LLC isn't a person and it can't occupy. So, I mean, that would be my approach. But some lenders will lend you money on an investment property as long as you say, I'm not going to live there. They do say that, there is a due on sale clause. There is federal law that says that if you're doing it for like estate planning purposes, it doesn't really trigger the due on sale provision. And generally, you can argue that you're transferring it to an LLC as part of an estate plan. That's entirely plausible, and I would agree with it. So that's probably going to be okay. If there is a mortgage on it, you're going to have to pay a realty transfer fee in New Jersey because it's considered part of the consideration. You would say that the consideration is less than $100. If it's less than $100, there's no realty transfer fee in New Jersey. But if there's a mortgage, that's considered part of the consideration, and you're going to have to pay a realty transfer fee. Number two, you always want to make sure that you deal with your lawyer and your title insurance company up front. It's true that if you buy a property individually, if you have a single member LLC, the title insurance by definition will transfer to that entity because you are the sole owner of the LLC. I think it works that way for husband and wife. I'm not sure. I always ask my title companies, and if you're planning on transferring title, not title, if you're selling membership interest at a closing so that the members will be different, we always run it by the title company and make sure that that there's title insurance. It's one thing to, at the closing, transfer membership interest. That's fine. You don't have to worry about it. But I've had clients who have had to close on deals with the intent of later selling their membership interest in the LLC rather than doing a title transfer because a real estate transaction, is time consuming and difficult. It's much easier to just sell your LLC interest. But you got to tell your title insurance company because you can get protection. It's called a fairway endorsement if you change the members of the LLC after the real estate transaction is closed or consummated. So, again, everybody works together, but you got to make sure you're covered from the title insurance. And Um, right. If you want to go on the next question for us?
Yeah, absolutely. So this one actually might be, I guess, geared towards me a little bit. So David, first of all, Dave, thank you so much for being here. Is it harder to finance deals with newer LLC, or can the operating entity finance the deal for a new LLC? So, Dave, maybe you could clarify a little bit. I think your question is does it matter to the lender if the LLC is brand new or if it's an existing one that you're already using? If that's your question, we don't differentiate. If it is an existing LLC, we'll just ask for a COGS, which stands for a certificate of good standing, just to prove that you're not being sued right now or under any penalties. And then if you're using a brand new LLC, as lenders of real estate, we completely understand that, like Scott was saying earlier, most investors are going to use different LLCs for each property. So we're already used to that. We know how to roll with it, and we can get that done for you as well.
Right, and you're gonna require guarantees. So, if it's two members or one member or whatever of an established LLC that's looking for deals and running a business, like I've said, and they're the same members of a separate LLC that's just doing it for asset protection, you're still going to have to personally guarantee the loan. The asset is going to be the real estate, Max, and is going to look more favorably on a deal that is properly structured to maximize asset protection, so that there is less danger, as opposed to an LLC that takes title to properties in the name under which it operates and owns multiple properties. There's always risk of litigation against one of those other properties that's going to affect all of the deals. So, it's a little bit more of a complicated question, but right, it's from the loan perspective, as Max said, the purposes are complementary.
Correct. But from a legal standpoint, that's where you speak to Scott, you let him know your situation, and you would tell you whether or not it's advisable or not.
Yeah, and right, you're gonna have to guarantee the loan anyway. So, right, it's like I said, from my perspective, it's smarter to just have an LLC that, like I said, it's a statute and it holds the deed. That's all it does. And you have property insurance. Max is going to make sure you have adequate property insurance and, of course, title insurance. So that's really what's helping you, for protection. Okay.
Sure. So now this one's for you again, Scott. So PJ is asking, if you have an existing LLC, how difficult is it to change the name and operating statement? Well, can you even change the name besides doing a DLB?
Yeah. Oh yeah. Yeah. You can file it's $100 to do any kind of amendment. Because it's 103.50. I was giving you because it's $125 to form an LLC in New Jersey, but because New Jersey doesn't want to pay your credit card processing, and they only accept credit cards, they charge you $3.50 generally as an upcharge on, what the net that the state of New Jersey gets, because the credit card processors are taking a fee out of that. So they added $3.50 to everything. So, right, a certificate of amendment is $100, but it's really $103.50. And like I said, and that you can do all at one time. You can change your registered agent, change your name, change your members, change whatever you want in a certificate of amendment. So that's easy. And you can do an amendment to an operating agreement. I like to start fresh and do what I call an amended and restated operating agreement that replaces any prior operating agreement. So yeah, it's easy enough to do. But listen, if you have a multi-member LLC, everybody's got to agree, obviously, to change it. That's all. Okay.
Understood. So now, Mr. Klein is asking for some recommendations on insurance brokers. So, Mr. Klein, I would ask you to kindly.
Send me an email, and I'll be happy to give you a couple names. I have a couple guys in the northern end of the state, and I have a broker that I like in Burlington County who operates statewide, but she's awesome. She's really good in terms of giving you options and for your coverages. All the guys that I would refer you to, would do a good job pricing and helping you on structure. But Janice in Burlington County, I really like what she's done for a couple of my clients in terms of suggesting some coverages, like for sewer and water lines. She has some companies that do that. You can pay American Water, for example, if you have American Water. to buy some insurance on the water line. You can pay your sewer company for some insurance on that. But she was telling one of my clients, I didn't realize it. There's some companies that will do riders and it's cheaper. So, why pay more, right? And I thought that was really, really helpful, particularly as you get some of these properties that are older. That's what you're running into is infrastructure is aging. So, I was like, darn, that's a great idea. Anyway, okay. Yeah, so send me an email and I'll send you some referrals. Okay.
So, Scott, I'm going to change this question around a little bit, only because we're getting a couple of questions that are very similar, I feel. So I think I might be asking in the best way possible, guys. If I'm not, just put in the chat and I'll re-ask it. But it seems to be people are asking questions about having holding companies or an LLC that holds an LLC.
Right.
I guess, could you just elaborate on how that works? Is it advantageous? Is it not advantageous?
Yeah. Right. Like I said, I want your operating company, the company that you're advertising under, that you're sending out and advertising, publicizing on social media. It's your website, right? That's your presence. That's your, window to the world or whatever. That's how people see you. That entity, I don't ever want that entity, whether it's the actual name or you register as an alternate name, which you can do, whatever it is, ABC Real Estate, I want you to have liability insurance. I don't want you to own any real estate. I just want you to have assets that are like cash and contracts, but no real estate. So you have some things to protect. You're going to have assets. You could be a subchapter S corporation, have employees, pay salaries, have a good cash flow. So you do have assets to protect, just not real estate assets. And so you can have liability insurance because you're operating, and it's not that much, depending on what you're doing. You talk to the insurance broker about, whatever kind of risk, whatever kind of coverage they think you need, and shucks, right? If you can lease or buy vehicles through that, so obviously you're going to need to have insurance for that. Make sure you have enough liability coverage, not only for whatever vehicle you're buying, but for whatever damage it might do. So just like anything, any business that's operating should have liability insurance, and whatever your insurance broker tells you to consider. That's just the bottom line.
Absolutely. So I
a
guess
great insurance broker is really good. You need somebody to take a look at your business and say, here's what I think, some coverages that are available and Joey consider.
Absolutely. And they'll also tell you what are some of the highest, what is the most common thing that people are actually getting compensation for from the insurance. So you could tell like, oh, wow, I probably do need this in this area. But a lot of the other questions are coming in that are also very similar. Is there any other insurance besides homeowner and liability that you would recommend an LLC that's holding real estate to have?
Those are the basic commercial general liability insurance, CGL. Like I said, that's why I talked to my insurance broker. What do you think I should have? What do you recommend? I have an umbrella policy, just for my own, on top of my own homeowners, and on top of your automobile policy, I have an umbrella policy that's like excess insurance. It doesn't, you have to have maximum liability. I think you have to have $500,000 coverage for your auto and then you can go, millions of dollars up to get umbrella coverage that covers other things that you're doing. So, it's relatively inexpensive. I highly recommend that. So that would be another kind of insurance. But again, you talk to your insurance broker or agent, whoever, and, get some good advice.
Absolutely. Rachna is asking about pricing to look at a new operating agreement. I would recommend that you email Scott or give him a call. We're going to shoot out his information. It's on the screen as well. Take a screenshot, write it down, but we will email it to everybody so you can reach out to him for more questions about working together.
It has to be published, and no publication in New Jersey. Nope. And no, your operating agreement is not, it's not something that you're, nobody has access to it. You give access to it, like your title company needs to see it because they need to know that you're authorized. It's, again, I hate to bring it up, but I do because it's part of what I do and part of what I see is litigation. I'm involved in a case where, sadly to say, a lawyer who has fled the country said he was the managing member of LLCs, took out some loans and then discharged them and sold some property when in fact, his clients didn't know anything about it. And the title company, frankly, in my opinion, should have done a better job at looking at the documents because they're not public record. The operating agreement is not a public record. The certificate of formation just has that bare bones information, like I said. It says nothing about who's authorized to act for the LLC, and there was no recorded statement of authority. So, unfortunately, we're in litigation right now, in Bergen County Chancery Court because, we got some issues. Sure, it wasn't me, that, right? I'm trying to help the guys who got shafted by, the other lawyer who I knew a little bit, and it was very surprising. But, unfortunately, these things happen. But there's recourse. Like I said, to me, I can't comment on what's going on, but it's in the context of answering that question. The operating agreement is what governs. It says how the LLC operates, and that's what has to be looked at. So any lawyer or title company is going to want to see it. But no, and you're obviously when you go to open a bank account, your bank's going to want to see it because if you're going into, and frankly now with I've had clients tell me that the bank wants to actually see their office. Like for a single member LLC, we want to see where your office is. It's part of like our due diligence now. I'm like, okay, well, what if you're operating out of your house? I guess they want to see your home office. I don't know. They want to see that it's real. They want to meet you. They want to know the customer. So there's all kinds of stuff. I mean, fraud. Oh my God, right? We don't even want to get started on that. Right, Max? I mean, it's such a crazy.
That's a market on its own.
Exactly. There are so many ways to experience fraud. The fraudsters are so clever, and it's just a never-ending barrage, right? I'm constantly getting emails. Your closing document is ready. Click on this attachment. I had a client email me is this a deal we're working on? And I'm like, dude, that's called phishing.
We used to make people sign a document every time that says, we warned you that there is a lot of fraud out there and you will not send money to anyone unless you call me about it first.
I put it it's on my email disclaimer. Exactly. Don't give any money to me unless you talk to me first. It's like, don't operate by email. And
they're even targeting the sellers now, and the sellers are supposed to collect money. And I'm like, why would you even think you're supposed to send it?
Right. I mean, right. That's job one.
It's terrible.
Where you verify. There's other things too, but it's just constant, and it only because in real estate the numbers can be very large. So if these fraudsters get one score and they're making, they're getting a mortgage payoff, it's supposed to go somewhere and it goes in their bank account. It's $350,000, particularly if you live in some third world country. And you're getting American dollars, it's like, wow, that goes a long way in some countries, right? We all know, right? You go on vacation and you see, standards
also, they bought an island.
Holy Toledo, right? 350 grand goes a long way in some third world countries, even some ones that are close to the United States. And even in the United States, you can get a score or whatever. It's not like $100 here and there. It's big money. So you really do have to be careful. You do have to be diligent.
Absolutely, guys. We're getting inundated with questions. Yeah. I'd love to get to every one of them. I just don't think we would have enough time in the day. So we'll pick another 2 or 3 more. Scott, do you want to pick in the Q&A, do you want to pick 2 or 3 that you think have the most value that you could kind of teach on and maybe answer those?
I see Clifford asked a question. Can you add a member with minority interest and protect that member from any type of litigation against the LLC? It doesn't matter what percentage membership interest you have. you can absolutely put in there, and you can make sure that the LLC has insurance, and that it's going to indemnify the members so that the LLC picks up the cost of defense of any action, whatever it is. And it's yet another reason why it's important to have insurance, because it's one thing for the LLC to say, sure, I'm going to indemnify the members, but it's another thing for, that to actually be worth anything. I get that. Max knows and I know because we do lending. So, a guarantee is a guarantee. It's a piece of paper, but it's unsecured. It's whatever assets that guarantor has. Now you can take collateral, right? Somebody could actually back up the guarantee by pledging collateral to support it. A mortgage, a lien through a UCC on certain assets, receivables, investment securities, all kinds of things. So, an indemnification is a guarantee. It's a piece of paper. It's just like getting a judgment against somebody. That's a piece of paper. There's a difference between having a piece of paper that says you're entitled to X, Y, and Z, and actually being able to, have it mean something. So again, that's another reason why you want to have insurance, because you know what? If you get sued and you have insurance, right? That's what it's all about. You have liability coverage in case somebody comes after you. That's when your insurance comes into effect. And you can, by the way, it's a common thing among businesses that operate. You can get life insurance on the members, and you can use that to fund a buyout. If you have a really nice ongoing business, man, you really want to. And accountants are usually very good with this. So if you have a business, you should have an accountant. And the accountants are getting you. Used to be called key man life insurance. I'm not sure what they call it now, but key person, key manager, or something like that. So because if you're rocking and rolling in a real estate business and there's two of you and you're not married to each other or in some kind of relationship other than business and professional, God forbid one of you dies, because then what happens? Now you're left with that person's heirs. And what are they going to do for the business? So, if you're really running a valuable business, you have a buyout provision, where you're valuing it and you say, you're going to use the life insurance. So guess what the heirs get? They get money, right? If there's life insurance on the person for $500,000 and that's what it takes to buy out that person's interest, and you're 50-50 owners, they're dead, their heirs get $500,000 in cash through a life insurance policy, and you get 100% of the LLC and run it as you want. Okay. I mean, that's, like I said, that's done all the time. So, you have a good lawyer, you have a good accountant, you have a good insurance broker. These are just tools of running a business. It's great to, talk to everybody. Max, thanks for the invitation.
Absolutely. I appreciate it. You've been very informative. We see we got a lot of questions, so you definitely piqued some interest. Let's
do some deals.
Hell yeah, guys. This is the time. This is the time of opportunity. When there's uncertainty, as my father always says, there's opportunity. And we got to make sure that we seize all of it. Got to make sure we're continually educating ourselves and knowing what's what, right? It's not good to be the uneducated investor.
Absolutely. So, right. And it's funny because, Max, you're like a partner that I would have or that anybody would have because you're a lender. You're assessing, like I always say, I have clients who, will send me home inspection reports and stuff like that. And if I'm not investing in the property, I'm not going to go visit it. So I don't know if, the electric panel needs replacing. I don't know if there should be, better ventilation in the attic, or I don't know if the windows are going to open or not. You have to figure out all that stuff and what it means. And that's why, Max, with all your experience, you're there to help your borrowers, adequately figure out renovation budgets. And, because you are a capital partner, to make sure that the price seems like it's right, because you want all your borrowers to make money. You don't want anybody to lose money. Sure, you get paid first because you're the lender, but, it doesn't make anybody happy to say, I paid my lawyer, I paid my accountant, I paid my contractors, I paid my lender, and there was nothing left over for me at the end. That's not the idea. The idea is to make money for everybody. So, Max is going to help you evaluate those deals. And like Max, like you said, there's opportunity. COVID has absolutely created opportunities, right? We all know that there's an eviction moratorium, there's sheriff sale moratorium in New Jersey. It's creating some problems with cash flow.
Creating noise.
Rent, right?
Creating noise right now. Like I know I speak to a lot of people and they tell me I can't find deals. People are finding them. They exist. Like I'm seeing deals come across my desk, now more than ever. So they're out there. You just got to find them. Honestly, you just got to find. You got to keep prospecting.
There's going to be distress, what we call distress. There's going to be distress deals that are coming up.
Absolutely, I'm excited. I shouldn't say I'm excited, but
no, dude, I'm right there with you because that is opportunity. Right? Isn't that Warren Buffett? Right? I mean, he says all kind, right? Like when people are running for the exits, he's running in. When there's right, the same. Like he's the guy that lent Bank of America money because he knew that wasn't going out of business. I mean, I say that all the time. I'm like, man, I should have invested in that because I didn't think that the government would ever let maybe Wells Fargo or something, but Bank of America. I mean, so I remember when the stock was like $3, and within a year it was 4, and now it's probably 30 or whatever, and this was in 2008, 2009, when the last
Chad said, buy when blood is on the streets.
Exactly. Right. So, but you got to be careful. You still got to get it at the right price. You don't want
careful.
You're like, oh, sure. I bought it 50% off the high. Yeah, but it went to 0, right? I mean, so you got to be careful, but there's absolutely opportunity. But I agree with your sentiment. And there's definitely pressures because we have the foreclosure, we have the sheriff's sale moratorium, we have the eviction moratorium. That's creating, strains because people aren't paying. There's tenants who aren't paying, and that means there's landlords who aren't paying their mortgages, but they can't get foreclosed on. So sooner or later, you're going to see, the tax sales can keep going. You're going to, when you get the, people aren't paying, right? So there's going to be mortgage foreclosure opportunities where people are, now's a great time to be looking at things like that because, there's time to get these deals structured. So
but don't forget, guys, there's still risk in these times, right? And more of it probably, right, and there's probably more of it than before. So what I want to say is work with professionals, work with people that do this, work with people that have been in these situations before, right? We're not going to trust our dentist to be our attorney. We're not going to trust our contractor to be our lender either, right? So work with the people that are best in their situations, and that's what's going to get you the furthest in this industry. This is a round table business, as I like to say. Yeah. Everybody, we all share the food,
right? And
we celebrate together.
And that's what makes real estate so great, as far as I'm concerned, because you really can't do it just all by yourself. You can't know everything, right?
Nope.
You can't replace a lender with experience, a lawyer, an accountant, a contractor. Everybody's got different skill sets, and to be able to cooperate with folks like that, and that's exactly what I'm saying. Like, I'm not evaluating your deal. I have no idea. Sometimes I'll have an idea if I know the neighborhood, but most times I don't. I have no idea if you're getting a good deal or a bad deal. That's what Max is going to help you with. My job is different. My job is to help you get it done and get it done right, so that you're
adequate. Sure, we don't get sued.
And then, you're at least able to, you have title insurance, so you know what it is that you're buying, whatever issues there are that exist with that particular piece of real estate. So it's been great. Thanks for everybody. Thank you so much, Max. Look forward to talking to you guys more later.
Absolutely. Appreciate you, Scott. You've been, like I said, super helpful, super informative, and we look forward to doing a lot more deals.
Everybody have a great night.
Bye for now.
Happy Halloween.